standing orders of Parliament does it give the Public Petitions Committee the power to make a policy? It's not in the powers of the Petitions Committee. They can only call for papers, documents, and people in order to for evidence to investigate petitions, right? Or like to the merits of, not the merits of the petition, but to interpret it, right? There is another committee that actually mentions policy, but that's specific to that other committee. Now the thing is, actually, all the way through these standing orders, when you search for the word policy, it's always in relation primarily, 99% of the time, to government departments out of the House of Commons, right? Like, look here. Select committees related to government departments. Well, the Petitions Committee is not related to a government department in the way that it's a judicial process of the House of Commons, right? It's a judicial function of the House of Commons. Government departments are not elected by the people, and they don't have the power to control the House of Commons. It's the House of Commons that controls the government departments, right? And the public that is meant to elect and, elect members into Parliament and be accountable directly to the public, right? It's not the public aren't under the control of government departments when it comes to making or changing the law, right? Now here, look, these are some of the departments that it mentions in relation to policy. Got Business and Trade, Ministry of Justice, Department of Culture, Media and Sport, Department of Education, Department for Energy and Net Zero, Department for Environment, Rural, Foreign, Commonwealth Office, Department of Health and Culture, Home Office, Department of Development, Ministry of Justice. But that is not the High Court of Parliament itself. Department for Levelling Up, Northern Ireland Office, Administration Expenditure, Department of Science, Scotland Office, Transport, Treasury, Wales, Government Equities Office, Department of Work and Pensions. They are all out of the House of Commons, right? They're not in the House of Commons. Now, there's a policy in these standing orders to do with MPs and crimes and sexual offences where there's a requirement to report them, right, if anyone commits them. But that is to do with employees. Again, the thing is, right, policy is usually to do with employees, right? When you choose to work somewhere, you are yourself under the policy, right? Because policies are in addition to law. But, private companies can make up their own policy and rules for who they choose to employ as long as it complies and conforms with the law, right? But I am not employed by the government, right? I am not a government employee. I'm not an employee of the House of Commons, and I'm not an employee of a government department. Therefore, I am under an employment policy, right? And accepting consent in policies is when you go to if you buy a service, sometimes they might get you to consent to the policy, like B&Q returns policy, right? But these are all private organisations. Now, the House of Commons is under the standing orders, right, and the law of England, but it's also privileged, which is it can regulate its own affairs, but through standing orders, right, but also through independent judgments. But this is the thing, right? There's actually nothing in here which gives the Petitions Committee the power to make its own policy, and there is nothing in here which gives a right to make a policy for the Petitions Committee by Parliament, right? Because it's not a government department. Now, when it comes to us, petitions to Parliament is a judicial function of the High Court of Parliament, not of the other courts. Right, and it isn't the Ministry of Justice either, because the Ministry of Justice is actually, we can make and change the rules of the Ministry of Justice, right, through Parliament. Okay. Now this is the thing, right? When we write a petition to government and hand it to our MP, right? Now, the MP is the judge, right? Because he will decide if he wants to endorse it or not. And once he decides to endorse it, that is a judicial decision, right? And he will present it to the House, and then it will be a judicial decision of the House, right? And then it goes to the Petitions Committee, right? Who can send it to different departments. Now, this is the thing. So, the Clerk of Parliament is appointed by the King, and they're meant to be the expert in the law. Now, they can advise the MPs, right? So they've got quasi-judicial power, they can guide them. But they're not an elected MP, and they themselves are not endorsing or rejecting the petition, right? That's what the MP does, but they can advise the MP. If the MP still wants to endorse it with his own judicial power, after taking advice from the clerk, then he still can. And then the House can judge that, it could still judge against it or for it, right? Now, so the clerk is an advisor. Now, there is the clerk, if there are certain things the clerk can do, like under the Parliamentary Papers Act, they can issue documents and certificates, and the Speaker can, right? Now, if they're doing that, I suppose the clerk has got a decision-making power if it comes to him, but they're usually presented by the MPs, right? And also, if we're presenting a petition about a judicial matter ourselves personally, like for grievance of privilege, and I think it's when they follow Understanding Order 155, but it's definitely like a judicial matter of privilege, right? The member of the public has the legal right to present it themselves, okay? They don't need an MP to present it, so they don't need an MP to endorse it or make a judgment. So it's your own legal claim, like to a court, right? Directly between you and the judge. It's the judge that decides, right? The court administrative officer, the court manager, or the clerks and so forth aren't the judge in a court, okay? Now, they've got certain quasi-judicial power on, when you fill documents in, or you fill the form in correctly, right? But ultimately, the actual claim itself, and the clerk can't actually look at the evidence, right? So the clerk can't say whether your facts are true or false that you've contained in the statement, only that if the statement has been put on the correct form, like things like that, and it's got all of the complete information, like have you put your name on there, or is your name missing, things like that. Not actually is your statement true or false, right? That's beyond the clerk, because that's the judge. And this is a thing that the e-petitions team have completely and totally gone beyond the constraints of what their job is meant to be, and they've actually been what's actually happened is they've become judges. They become like MPs, and they're not MPs, and they're not the Speaker of the House, right? They just have to make sure that you filled it all in, and you put your name on there, and check the emails and things like that, right? Now, Erskine May was a Clerk of Parliament, right? Now, Clerks of Parliament have traditionally been writing these books, but remember, they didn't start till 1844. Now, in 1832, right, the rules were very clearly set out for public petitions by Sir Robert Peel taking evidence from members, right? And it was clear that, actually, what Erskine May put in his book later on, it was only the advice of a clerk, really, and it was a lot more stricter advice on petitions than what the actual truth of the matter is, which there isn't necessarily really any rules, right? Obviously, you want to be polite, or the person receiving it is not going to be very happy about it, right? But apparently they were very strongly worded. Now, when Erskine May writes the book, the first version, and then subsequently other editions are published by other clerks traditionally, that book is not the law, and that book isn't the standing orders. What it is the legal expertise of the clerk advising the country, right? In their opinion, what the rules and practices are and should be. But similarly, right, Similarly to, like, we've got George Strickland MP who never had a petition rejected, right? The MP can be advised by the clerk not to present it, but the MP can still choose to, because it's his judicial power, right, to choose to present it, like George Strickland, right? And then if the House want to vote against it or whatever, or the Speaker, right, and not act on it or reject it, then that's up to the House as a judicial body, right? But the clerk only advises, and it's up to the MP presenting it himself. Once the MP has what you call endorsing it, written his name on it, it is then officially received and accepted, even if the petitions committee send it back and say we don't know where to send it to, right? And then the House have to decide where it's going to go. But even if they don't act on it, it still was received officially. You can't have this. There isn't really this rejection. And then the other thing is, right, the right to submit a petition, and if your MP does not endorse it, because you've got a right to surgery with your MP, and because you've got a right to surgery and discuss and debate with your MP, you've got a right to explain to the MP why it is submissible if it wasn't submitted, without having to change the text on it, keeping the signatures on there and having to re-get them again. You've got the legal right to explain it to the MP why it's submissible as it is, right? And then the MP has got the right to do that himself, to the clerk and to the House, which is what George Strickland did. He said that he'd never had them rejected because he'd always been able to explain it, its admissibility, right? Now, with the Petitions Committee is meant to be jointly run by the government and Parliament, right? Now, the problem with government, as opposed to the House of Commons, is government and departments have employees and staff who aren't elected MPs, and they have staff policy, employment policy, right? And they can have policies when, people use their services and so forth, but it's not necessarily the law, right? Now, the House of Commons is not a government department, right? And it has elected members. Okay, they have like receptionists and staff, and the clerks are appointed by the king, right, and so forth. But as for public petitions, is unique because it is the High Court of Parliament, and it's a judicial process and function under the privileges of Parliament. They've got their own legal right to make up their own rules and debate their own matters, but under the standing orders, which are the official rules. Erskine May is only a guide. Erskine May is like having the clerk, right, in a book, rather than consulting a clerk of Parliament in person, right? If you cannot have a clerk in Parliament available, or if you're at home and you're writing in, you consult the book like you're consulting the clerk, right? It is not the law, and it is not itself the standing orders. Now, we sort of find this when they're doing the privileges reports, because they've started having this habit of, whenever they mention Article 9 of the Bill of Rights, which is their privileges, they don't tell you what the law is. They don't say Article 9, that illegal prosecutions by the King's Bench for matters cognisable, decidable only in Parliament and other diverse and arbitrary causes, right? They instead say, hey, it's Article 9 of the Bill of Rights, and then take the writing away of what the law is, and then switch it with this paragraph that they've all been passing around, right? Saying that, it's the sole right of, members of Parliament to judge their own matters, blah, 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 blah. That's not what it says in Article 9. That is the opinion of a clerk. So what they've actually done is, whenever they put the heading there, the title of the Article 9, so it's almost like if you go into an art gallery, right, and there's a painting by Leonardo da Vinci, right, and it says in the frame picture, the Illuminations by Leonardo da Vinci. You expect to see the Illuminations by Leonardo da Vinci. I'm not saying that he has got a picture called that. It's just like a random example, right? I made it up, right? But if you go into an art gallery and they've got a framed picture on the wall which says Leonardo da Vinci, the Illuminations, right? Then you want to see the Illuminations, right? So it should say Article 9 of the Bill of Rights is illegal prosecutions by the King's Bench or other for diverse and arbitrary causes, right? It shouldn't actually have there a comment, an opinion of a past clerk of parliament, right, replacing the law and framed in a picture with a writing on saying Article 9 of the Bill of Rights, but yet in the picture frame is the opinion of a clerk of parliament, right? Because then that is not the genuine article, right? It's a opinion of it. So, like, it's like a review of a painting. You don't have, like, in the museum, like, an impressionist artist or a painting by Pollock, right? But it's actually not Pollock's picture in the painting. It's like, some magazine editor's opinion of it, or another person's painting, right? Which is like based on it, right? Then because that's not the painting it claims to be. And that's what they've been doing in these privileges reports, and not mentioning five Parliamentary Privileges Acts, starting with Strode's Act, right? In the 1500s, 5 acts. Even, whether or not they're in force or not is not the point. The point is that they existed, and some of them were made after the 1688 Bill of Rights, Article 9, and they have a legal basis in them for privileges of Parliament, right? And there's 5 of them. So you can't, how can you get through a government committee report on privileges in 2012 without mentioning one of 5 acts on that subject? You're really wanting to get people to forget about them. But yet you mention an Australian Privileges Act, right? So you're either trying to conceal, hide them, or ignore them, and substitute the actual true law itself for the opinion of the clerk, which is what everyone sort of believes Erskine May is the law, but it's not. It's the advice of a clerk, right, based on their experience, but it isn't the law or the right. So coming back to Parliament again, when a member of the public presents a petition, Mr. John Tinker, who is backed up by Gilbert Campion, by the way, right? So John Tinker MP, 1955, backed up with 1944. Sorry, not 55. 1944, backed up with Gilbert Campion, and seconded by other MPs, right? He said that we, the public, don't have to have a petition endorsed by an MP, so it doesn't have to be adjudged fit to be presented by any MP, any member, right? In order for us to present it if it's a judicial matter, right? So that means you've got a direct legal right to be adjudged by the Speaker of Parliament and whatever MPs are assembled, right? Now, the clerk can advise you on what is presentable in that petition or not. Like, have you got your name in there? Have you got your address, email? Did you fill all the things in which are required to be on it? Is it addressed to the right place? It's not addressed to the butchers. But remember, the clerk is not judging your claim. So whether your witness statement is or is not true, and whether or not any of the information within the section on, when you get a court form, right, you've got a section to say statement, right? Fill it in, right? The clerk checks if the statement box has been completed. If you ain't filled it in, right, there isn't a statement on there. Has it got a prayer on? Is it asking for something? Not what are you asking for, really, or can you not ask for it, right? Unless, we can get creative with it. I want Boris Johnson to go jogging in Union Jack boxer shorts, right? While England flags are being taken down with for a Conservative. Well, no, Conservative Party advert is not something that Parliament can do because it's Conservative Party, right? But you could get the Prime Minister to do some kind of, some kind of like English stunt for England, some kind of, national statement, almost like putting a statue up, or announcement, I suppose, if it's, or something like that. Although, really, I don't think the MPs are meant to do promo even when they're working, because, they're not entertain. They're not meant to be entertainers. They're meant to be doing, serious, important government business. So all this pulling pints with sheep while they're the Prime Minister, the Prime Minister wants to stimulate the, brewing industry. So he did some photographs in a pub, to say, let's all go out and have a pint, because he wants to encourage it, right? I suppose he can do that. It's debatable, but, is it a gratuitous self-promotion and an advert for his party, or is he truly, wanting to stimulate the brewing industry or whatever, and for business? But that private businesses, should he be helping out in businesses? Should he be helping out private businesses? So, but the thing is with the petition, it's open to creativity, right? Now, it's if you've got a civil claim and someone owes you some money, it doesn't matter what they owe you money for. It could be anything, right? So they could owe you money for fixing your sink, or they could owe you money for a holiday, or they could owe you money for, something that they've got of yours, but if you don't want to prosecute them for stealing it or whatever, right? So they want the money for it, right? They can't say, you can't claim money for chocolate bars, but you can claim money for, bus fares. It's money, right? It's financial. But with the government, it is for a redress of any wrongs being done to you by councils, governments, anything to do with governance, right? How he's governed. But also other parties, though, might have broken the law. That's what crime's there for, right? Wrong. It's still a wrong against you by another citizen against the rights of the country, right? It's your right not to have that done to you, okay? But currently, they're trying to... So the petitions committee now are trying to say that, let someone else deal with it. No, you've got a right to have it taken to a higher authority, right? If you cannot find redress or obtain redress at that level of government, or any level of government, you've got a right to seek redress at the highest level of government, right? So when you present the petition yourself, if it's over a grievance of a judicial matter, you're directly answerable to the Assembly of MPs in their vote and the Speaker, right? The Speaker, not anyone else. Now, the clerk can advise you, but the clerk can also, is it filled in properly? But that is not a judging what is written in the statement box or written in the prayer, right? Checking to make sure that it's addressed to the right place to start with, right? And that your name's on there and so forth, that's supposed to be what now, and the clerk can also advise, but courts always say they can't give legal advice. If you could get, if it was, as soon as you go into a good evidence on this, right, is if you go to a civil court or a criminal court, the clerk will usually, we can't give legal advice, but miraculously when you're in the High Court of Parliament, then they're wanting to not only give you legal advice, but also, tell you what you can and can't do. The clerk, right? They should be going, no, I can't give legal advice. Well, have I got the right address on it? Is it to the right court even? If you're in Worcester, if you're in a criminal court in Worcester, right, and you fill the form in all handwritten, say, this is addressed to the right court? I've got the wrong court. Excuse me, am I in Worcester? I can't give you any legal advice. Excuse me, have you filled the court form in at the top properly? Is it addressed to the right place? This is the thing. So when they even got into this business of the clerks trying to talk you down or talk your cases out, as opposed to have I completed everything that is required to be completed, right? It's that, you want to be weary of the government when they suddenly want to give you something or help you or want to give you advice. We want to help you. Well, when I'm in the criminal court, you don't want to give me any advice or any help, That's strange. It's a clerk function of a court. The judge is here to decide me, right? The MPs and the speaker's here to decide, Suddenly, the clerk's giving all the legal advice under the sun. He's written a book about it, Wouldn't it be great if, the clerks of the criminal courts were writing books about it? There's plenty of legal advice in there, This is the thing. So you know what does fall in and fall out of legal advice is conveniently expanded or shrunk depending on whether they do or do not want to help you out or not, right? But so you've got the legal right, okay. If you're presenting one of these judicial petitions to Parliament or a grievance where the MP does not have to endorse or present it, you actually have a legal right to dispute its submissibility with the clerk, if everything's been filled in or not. Like, say, it hasn't got your name on. Yes, there is my name there, so I'll explain it to you. There's my first name, there's my last name, right? You've got a right to explain yourself and explain the document, right? So you've got a legal right to negotiations at the point with the person, right? Which is a conversation, which is not what they're doing in this e-petitions thing. They're saying, like, speak to the hand because the face ain't listening, right? They don't want to, they're saying they can't engage. Well, actually, to refuse to engage in submissibility of documents in a judicial process has to be an abuse of process, right? If you're in a judicial process of law and it's called the observation of the due process of law, right? Observation of due process of law, right? If the clerk will not talk to you about the particulars, what he is allowed to talk to you about, which is, have you completed everything and so forth? Is it addressed to the right place? And is it qualified for this court? It is an abuse of process if that clerk will not speak to you or engage. It's almost like going to the reception of the court and asking a question, where's the toilets? I don't want to tell you where the toilets are. I'm not going to speak to you, right? Oh, the building's on fire. Excuse me, where is the fire escape? Oh, I can't tell you. I'm going to engage with you, right? So these are abuses of process. And also because it's not just any old process, it's actually you're pursuing a judicial process. It's a perversion of the course of justice. You know what it's like? What this current e-petitions team now, what their supposed policy is, all right, we're not allowed to engage with you, right? It's almost kind of like saying, you're not allowed to you're not allowed to open the Erskine May book, or you're not allowed to consult with the Erskine May book, and obviously a book can't, well, the book does speak to you. Maybe you can't speak back to the book or not, but if the clerk's there in person, definitely you can speak back to the clerk, right? Now, they can't take that away from you because it is a judicial process. Now, when it's not over a judicial matter, when it's like a matter of, the law of the land, like, matters of religion, church and state and so forth, right? And private, submitting bills to Parliament, petition for bills, which they've put in a whole separate thing now, and local councils approach the Parliament to put bills through, but mysteriously local councils do not ask their local people to sign petitions to get things done by the government through public petitions, where they're both petitions to Parliament, right? Whether they want an act of law made or oppose a bill or some other remedy, right? Now, the councillors might even employ one of these parliamentary agents to propose legislation for local government, right? And they'll get it sponsored. They won't bother asking the public to sign it now because they don't need to, because they've got a big bag of money that they give to the parliamentary agent, and they get, minimum number of sponsors, like signatures, which probably will be the councillors or whoever, and the lawyer agent, and then they proceed to Parliament. But they could do it over any redress of grievance. It doesn't have to be a legislative solution, right? And they might not want a parliamentary agent or need one because they've got legal services as well in the council, right? Now, if they're not competent to draft up a public petition, right, then who is? This is the thing. They don't ask the members of the public, we got, 10,000 people from our area to get a redress because, and what if the council aren't in agreement, right? Well, this is the thing. When the council vote and so many councillors vote for something and so many councillors vote against something, This is the thing that, they're not coming to an agreement, are they? Or if they can't come to an agreement, well, usually it's the majority, right? But this is the thing. What happens if some of the councillors vehemently disagree with the other councillors, right? And they want a resolution because they haven't come to a agreement. Well, you say, well, there was an agreement because the majority voted, but, it's like, well, they want redress. They want to seek a higher power, a higher opinion, right? So we'll petition Parliament over it and get the people to sign. So they do it when, if they're not happy with they're not happy with, legislation that has been put through or whatever, then they're soon complaining, about it. This is the thing, and that legislation is coming from a higher place anyway, right? That legislation is coming from a higher place than the council anyway in the first place, but apparently they can seek redress from it. They can seek redress with the government, but yet it's coming from a higher place, How can you get any higher than the council? This is the thing. So what the council are doing is because the political parties have got control of the council, they're thinking that, we don't, the public have elected us, now we don't need the public anymore because we can just do what we want. And obviously if we come to a majority agreement, then, whatever. But what if those other council members who lost aren't happy with that result and don't want to accept it and want to get public backing to petition the government for a resolution? This is the thing that they've scrapped. Well, they haven't scrapped it because people were doing it. And it's this new ridiculous policy which is misleading and deceiving people, right? So we have a direct right to Parliament and obviously to dispute with a clerk, two-way dispute about admissibility, present a petition to the House, and if they, don't accept it, if the MPs or the Speaker, don't judge in your way, then fair enough, right? Well, this is like you had a case and you tried. I went into a magistrate's court, right? I prosecuted someone privately and I lost, right? All right, that was case 364. It was on the 27th of February. The plaintiff lost, right? But it existed. What they're saying now is they're trying to make out that I know that it's on the system and it gets recorded and logged with a number, right? But they're saying this rejected thing like it was never submit. They're making it sound like it's not official, that it's not a claim, that it wasn't accepted, that it didn't even make it in for a judgment. And the team are not the judges. They can't judge anything, right? This is the thing. They judge nothing. Now, if the committee have really made the judgment and told them to reject it, that means that you had a case, it was received and accepted, and you lost. So you shouldn't say rejected. It should say, you lose. Like, case, plaintiff lost the case, right? Which is different to having a rejected case, right? Unless they're treating it like a rejected appeal. This is the thing, right? But they're not. They're trying to make out that it wasn't something that you could take to them, or it wasn't something they could decide. That's not decided. That's different. It's like trying to put the judicial power outside of MPs or outside of a committee to some sort of staff, right? It's not a staff thing. Anyway, so coming from the approach of MPs, right? So like I said, the MP can consult the clerks and then they can choose to endorse it or not. Once they write their name on it, it is endorsed regardless of at a later stage whether the committee, kick it about and chuck it about or don't know what to do with it, right? Or if nothing gets done with it, right? Many of the petitions which were received sometimes didn't get anything done about them, or didn't there wasn't but in the history books, it says that Parliament is pledged to redress every grievance, to resolve every dispute, right, if it is within its power to do so, which definitely is not the case now, because they're trying to make the excuse that it's not something that you can take to them, or it's not something that they can do anything about, which is absolute tosh, right? You don't want to. because they don't really want us to override these parties, these Labour control of councils, control. It's all about control, because if they redress your grievance, the redress might be something that their own manifesto or political thing didn't want to do, and that means that it's not possible to get a redress because of partisan politics, right? Which you might as well just say, if you've got a Labour MP who doesn't want to meet you or talk with you, right? Because you don't fit the description. In a way, it's a little bit like that now with this public petitions team. They're saying you don't meet our criteria. Well, what's that? Well, you're not a member of the Labour Party, and you don't vote Labour, and you don't follow Labour manifesto. So I'm sorry, you don't. It doesn't qualify with the policy, right? That's effectively how we're being treated now by this petitions committee, right? It's like going to your MP and him saying, "Hello, sir, are you a member of the Labour Party?" No, sir. Do you follow our manifesto? No, sir. Well, I'm sorry, I can't deal with you because I'm a member of the Labour Party and I got elected by Labour people. Therefore, you don't meet the criteria. You don't meet our policy is that, we only accept things from people who are members of the Labour Party. It's effectively like that. That's what's effectively happening, right? But they're using other excuses. They're using, they're trying to make other intelligible excuses, which are all contrary to the whole point of it existing, right? It's like going to an ice cream van and saying, "Can I have an ice cream?" No. Why? We don't accept requests for ice creams. Yeah, it's an ice cream van. Oh, I'm sorry. Yes, I know it's an ice cream van, but we don't take orders for ice creams, right? Well, can you have an ice pop? No, I'm sorry, sir. We don't take orders for ice pops, but it's an ice cream van, right? This is the government. Here's redress of grievances. Oh, welcome. It's like, what was it say? Oh, it's to redress all grievances and contest elections and sort out malpractices in government, right? To resolve malpractices in government and, to remove evil ministers. I'll have that, please. Oh, no, we can't accept that. But that's what it's there for, right? So it's dysfunctional. What it's doing is it does not want you to have access to the full extent of the purposes it exists, because some of those they don't want you to do them. It's like VIP, very important person. It's like having a VIP pass, right? They don't want you to have the VIP pass, which is the right to petition, access all areas, access all grievances and redress, right? Because, some of those areas of redress and grievance encroach on these VIPs, very important people, removing VIPs from government or getting redresses which, don't reflect well on them, or point out malpractices they've done, or make changes to government which, their policies and manifesto really don't want you to make changes to, right? Which means that, but they're not just saying, "Oh, I'm sorry, we had a look at it and, we're not going to do it," right? They're saying that, it's not, they're lying and saying that, it's not what they're there for, right? When it is. So, this is the thing. But anyway, so these MP endorsements, when they sign it, right, the MP can argue with the clerk, and you can argue with your MP, because you could go to surgery. That's what the surgery is there for. I went into Parliament, so if the MP says I went into Parliament, the clerk advised against it, right, and I presented it anyway, but the MPs voted against it, then you lost, right? But if he says that, the clerk told me that it's not submissible, this or that, then you've got the right of surgery with your MP, you've got all those signatures on, you filled it in, and you can explain to your MP, "I'm sorry, I'm in surgery now with you," which you've got a right to do, and, you said the clerk said this or that, well, I think that this or this point they're wrong about, and so forth and so forth. It's like correcting Erskine May, right? Because Erskine May is not the law, right? So it's like, correcting errors or mistakes in Erskine May, right? That's what it's like. And then you send your MP back because he's at your service, and then he explains it, and then if it gets accepted, even if afterwards they vote against it, right? But then you had a case, but they're trying to make out now that this, like, that it's not presentable, right? So the thing now, they can't have a policy on that because, okay, so your MP is privileged because he's a member of the House of Commons, which is the High Court of Parliament, right? Now, like I said, there is a policy on the employees of Parliament have got to report if an MP's, committed a crime or certain sexual offences, right? They're under employment and obligation to do that, right? I don't have to. Right? Maybe under the common law of England, right? Report to a police officer. But you see, notice that Parliament's policy on reporting sexual offences to MP can't compel me to do it, right? That's an example of Parliament policy, right? If an MP commits a sexual offence, right, and I'm a constituent, I do not have to report it to the Speaker of Parliament, right? If I'm subjected to policies of the House of Commons, show me how they can force me to report a sexual offence, to the Speaker. Like if you're in surgery with your MP, like Jimmy Savile, right? An MP touched my leg, I might have liked it, right? And that compelled to report it to the Speaker. It's not my policy. I'm not under that policy, right? I am an elector, right? I am a voter. I am employed by Parliament. I'm not a clerk, and I'm an MP. And Parliament are privileged to regulate their own matters, and they can suspend certain rules. Now, I might say, well, can they write the policy then? Well, this is the thing, right? Every petition is a separate and new claim, right? And it's to be judged on a case-by-case basis, because each MP is an individual judge. So they are the judge themselves of whether they endorse it or not, right? But if you present it yourself, if you've got a right to on a particular matter like judicial matter, you don't need them to endorse it, right? Now, if they do not act on the case, then they don't act on it if they don't provide redress or they judge against you. That's like losing a court case, but they're trying to say that, it's not you didn't get into the court, right? That's the thing. It's not in court. It's not in, you didn't get into the court. This is the thing they're trying to make out, which is tosh, absolute tosh. Now, if you look at the policies in the standing orders, there is a committee that can do policy, but only for that committee, right? The Petitions Committee cannot make up its own policy. It is only given powers to command documents, persons, and papers in order to investigate things, not command papers to make up its own policy. It's not given that power. Now, that Public Petitions Committee is meant to receive judicial claims from the public in an electronic form. And so therefore you might say, right, well, there's a committee with a chairman and members. They're judges in that committee, right? But that's not the staff. The Petitions Committee staff are not elected MPs and they don't have judicial powers, right? And the Clerk of Parliament can advise them. Now, you might say, well, the Petitions Committee staff are employed by government and they are under a policy. So they're under a policy where, as employed staff, they are told that they should not accept these certain petitions on this and this and this and that. And because they're government employees, right, they can be under a policy. But I'm not under a policy. I am not under that policy. If someone has told them that they've got to reject this and that petitions on this and that criteria, right? Now, is the House of Commons a High Court of Parliament, or is it the government, a government department? Now, if it's joint, so those four staff can be under a policy if they're a department of government, right? But if they're working for the High Court of Parliament, the House of Commons, then they're not under a policy if they are part of the Petitions Committee, right? Because it can't make a policy up for itself, right? And they're not allowed to refer, they're not meant to refer for any advice or direction from government departments because they're not elected MPs and they're not in the Judicial Court of Parliament, right? And that was proved in one of the committee reports in the 1944 one, that they were referring to government departments for advice, because we might want to abolish these government departments or change the rules, and the government department might not want you to, but they can't make a judicial decision in that, right? the House of Commons make a decision and vote on it, right? We're not under control of government departments. Government departments execute functions, right? And regulate, driving licenses and things like that, right? But whether I want to get the law of driving licenses changed, and whether I want to change the processes of that department or anything, how it's run, or abolish it, I am not governed by that department. The Department of Transport does not govern me when I petition the House of Commons to change governance of that department. Otherwise, it is obstructing my ability to take control of it through the electoral democratic process, right? It's in control of me when I apply for a driving license for its processes, not when I submit a petition to the House of Commons, right, to change those processes. So I aren't under any policy or anything. Now, so the House of Commons, this is when we look through these standing orders, because the House of Commons, therefore, as the High Court of Parliament, it can actually suspend any rule. It can vote, but it's by the vote of the House, not by policy. They can't suspend the rule by the policy notice, right? Now, they could suspend that rule on that policy on sexual offences, right? But they'd have to have a vote in the House on it, right? Or standing orders they can even suspend. Now, this is the thing, though. So, now, the House of Commons is under privilege of Parliament and standing orders. But asking me is only the advice of a clerk. The best advice of a learned clerk, right? Which, we take that advice or leave it or not, right? This is the thing. But standing orders are written down, okay? But all decisions made through and under standing orders are by MPs. Now, the Petitions Committee is not the full Assembly of Parliament. Now, this is the important part now with the e-petitions. If we are not submitting petitions to our own MP, who is going to endorse it or, enter surgery with us to debate whether it is endorsable or submissible, or with the clerk, if instead, right, we're going to go to this online thing which is run by a particular MP, Jamie Stone, and a committee of members who are therefore a judicial body in Parliament, right? Now, does that mean that Jamie Stone, therefore, is the responsible MP for all e-petitions instead of your local MP, right? Now, if Jamie Stone, therefore, as an elected MP with a judicial position, can himself choose to endorse e-petitions or not, and everyone on that committee or the assembly of that committee is, and the staff are acting under their order and command, right? We still have a legal right, as you do with your MP, to surgery with Jamie Stone to dispute or discuss the submissibility of your petition on the clerk to run it, because it is a right of public to MP of surgery. Otherwise, it's an abuse of process and a perversion of the course of justice, because it's a judicial function and process, right? If you are engaging with Jamie Stone MP, who is appointed in charge of the e-petitions with his committee, right? If you cannot have surgery with him and his committee to discuss the submissibility of your petition, right? You don't have the right of surgery with that MP or committee, which is a perversion of justice, an abuse of the right to surgery with whichever MP is responsible or dealing with something, right? Because you have to be able to discuss the parliamentary matters with the representative who is being put in charge of it, okay? Just like within public inquiries, should it appear to a minister, right? That there's evidence of this or that. So now, so what about this policy then? So they've got this policy. They've put these staff members under this policy, right? They can't put us under a policy. I'm employed by the government, right? When I tick the box, I'm ticking that this. I say that the information I've submitted is true, and that is my name, postcode, and email address. That's what I'm ticking in that box, and that I support my petition, right? I ain't agreeing to no policy on there. I'm employed by the government. I am not under a government policy, right? Not for public petitions. So the staff are being told how to conduct and behave, but yet they're not a government department because it's a judicial. A government department cannot deal with judicial claims to the government, right? It's joint owned. It's the High Court of Parliament, right? Now, these standing orders here, right? They've got the word policy through here, like I said. It's suggesting that it applies in 90% of this thing to government departments, not to the House of Commons chamber or a committee under there. And the very few instances of committees that have got policy on here are in relation to this. They're not in relation to the judicial functions of the House, right? Reporting certain things like, you've got to report if someone's committed a crime, things like that, right? They could even, but that's not us, and it's not about how, there aren't, the standing orders of that committee also, and the presentation of petitions and so forth, don't have a policy because it's under the jurisdiction of the House. It's under the endorsement of individual members and then the judgment of individual members. And, so what they're trying to do is create a policy which they haven't even given anyone any power to create that policy for that committee, and that it's not for creating policies of the overall House anyway, according to this, right? It would be like all MPs of the House voting on a new standing order, basically, or voting on a new rule, but it's not a standing order. And it's not the law of a new rule. It's a policy, right? Now, if they say, no, well, all MPs, voted on this policy, but it's not being put into the standing orders of the committee, though. So it's not a standing order. And in fact, who signed that committee? If every single member of the House of Commons, right, voted on those policy clauses, why aren't they in the standing orders of the committee? They're not, right? So they haven't. Because actually, who has signed it? Well, actually, the leader of the House of Commons, who is a partisan politician of the Labour Party, who is in control of the government or for a political party, right? Supposed to be leading the Commons, and the chair of that committee. Now, the chair of the committee doesn't have power to create a policy under standing orders of his committee. And I see no power given to the leader of the House of Commons to create a policy for the Petitions Committee, right? Or for any overriding of the judicial functions of the House. There is no power given to the leader of the House of Commons in a personage in wanting the leader, right? The leader cannot actually make up rules of the House by themselves, even with Jamie Stone, and sign it, because only the whole House of Commons can vote on what the rules are meant to be in standing orders or approve them, right? But they're not. Because they're not standing orders. This is the thing. And like I say, for public petitions, because it's a judicial function, every single petition is adjudged by a different MP, right? On its own merits. And what is submissible or not even in Erskine May, because even Erskine May is only the advice of a clerk. And there's nothing in the standing orders that go into the details of submissibility, right? And so, therefore, it's more accurate that Sir Robert Peel, in his 1832 committee evidence, was questioning MPs on what is submissible or not and how they've been doing it, was that, they use very strong language, generally. they're asking for certain things, but I usually am able myself to adjudicate on its submissibility as to my own personal skill and qualifications, right? I qualify it through my personal skill and engagement, right? And that's one MP, right? Whether one MP endorses it or not is actually not the business of the other MPs until he has endorsed it. Once he has endorsed it, he has endorsed it. He has endorsed it and judged its submissibility, right? And, whether he's ignored the clerk or not, or taken the clerk's consent, and then it is adjudged by the House. And if they judge against it, then, then you lost, right? But they usually pass it on to the petitions committee to be sent to different areas for who can best deal with the problem, or because Parliament is meant to be pledged to resolve every grievance, right? But this is so this is the thing. The petitions committee are saying that they don't want to have surgery with anyone who's submitting petitions, right? And they told this team not to, right? Well, that is illegal, because the responsible MP is refusing to engage with the public on the refusing surgery, basically. They're refusing to provide surgery, right? Which MP is responsible for these e-petitions, right? Jamie Stone, right? Can I have surgery with him over it? No, he didn't want to speak to you, right? Well, that's, so you can't have it, because they're trying to make out that, right? So this is the thing, right? If you put that petitions committee policy, right, into your MP surgery, how's that going to work? We say, right, you don't have a right to surgery with your MP, right? You don't have a right to surgery. If they put that policy in the surgery, you don't have a right to surgery. You don't have a right to it, because he's not going to talk to you over the matters. So how can you have it? If you can't have it in the surgery, how can you have it on freaking e-petitions? Because they don't want to talk to you. This is the thing. How can you have it? Right? You can't have it. You can't have that policy. So, who's got the power to create it? 2 MPs cannot make standing orders of Parliament together. And it's actually, petitions is your own, and they're even telling you to go get your own MP to do it, so that's evidence that it's submissible. And if it's submissible to the MP, though, it's submissible on e-petitions because they're meant to be convenient. It says in the reports that they created it because it is possible to do it in forms other than on paper. The reason they created it because it was possible to create it, because it now is possible to do it electronically, whereas previously it was not possible to do it electronically. They even claim in the report that it's for the same purpose, which they're coming out of all this complete other tosh now. Like, oh, go see your MP or do it in paper, right? Which, how is that inclusion and diversity? What about disabled people? This is the thing. Oh, we can't travel. And they're even telling people, don't speak to strangers, or don't put your details. And in fact, the whole thing has lost transparency. They're taking away transparency. Tony Blair's like freedom of information, freedom of information, freedom of information. They don't actually want us to. Tony Blair's mission was, we want everyone's information, and in order to initiate that, we'll make out that we're going to let you have all information about the government, not the private, not Tony Blair himself, not Anthony Linton Blair in his own personal private life. But the idea is eventually we'll coerce you into giving us all of your information, private personal information, after, it's like Tony Blair goes into, all these MPs aren't giving you their private personal information, they're giving you the government's, right? It's almost like going to the swimming baths, right? You can just go help yourself, go and get some, bleach out of the cupboard or whatever. You can, go into the coffee bar and, fill the coffee machine, right? It's freedom of information. You can go into the swimming baths accounts. You go into the secretary office and look through the cabinet if you want, right? It's public owned, I don't care. I'm going home after into my own private life, but you can't know anything about me or my private life. But well, you paint the swimming baths red, right? This is the thing. But what Tony Blair now is doing is all of these private businesses that have taken over and bought everything are not giving freedom of information. They're not transparent, and in fact, what's happening is they've turned it around, and now the government even don't want to be transparent anymore. They've suddenly decided, well, actually, we don't really want you to know anything. We don't want you to know who signed these petitions. We don't want you to know who signed your own petition. You asked 5 people, well, which one of them signed it? Now I don't even know, right? They don't want you to know anything. It's Tony Blair's mission was, how can we have freedom to everyone's private personal information? How can we coerce them into doing that? Well, we'll make out that we're going to give them all information about everything else, but not us. Not our companies and businesses that are taking over the world, just like, the public swimming baths, like government, Parliament, the House of Commons, ask the government any information, it's not our own, it's not my own private personal life, it's just, the government, go to the House of Commons and take a pee in there for all I care, or have sex on the floor, or whatever, Penny Mordaunt's been up to, apparently in the newspapers or whatever, I don't know, according to Supertansky was saying, they don't care if we know everything about the House of Commons, because it's the House of Commons and they all go home afterwards to their own private life. It's almost like, the Manhattan's Tea Party, this is the thing. You can have as much information on the Manhattan's Tea Party as you want, right? But after we're all going to our own houses, you can't know anything. And by the way, it's been taken over by a private corporate entity which won't let you know anything. But it's wanting to know everything about you. This is the thing. What's happening? And in order to get control of this whole thing, we need to do petitions to get control of the government. But it's lying, giving out false statements about stuff. So, anyway, the fact is, on this list for policy is not the Petitions Committee and not the Chamber of the House of Commons, that's for sure. And the Petitions Committee itself is not given any power to create a policy, right? And for a judicial function of the House as a whole, you can't have one, particularly not one that says you don't have a right to surgery with your MP or whoever's been appointed to run the petitions, because then you can't function. It's dysfunctional. What they're actually wanting to do is that they don't really want you to be able to use it properly. That's the thing. It's a little bit like if you go into a court building, right? And they've got the security guard and he searches you and checks all your things like that, right? It's almost kind of like saying, like the scan thing's not working, you can't use that. We've got a new policy where you can't actually have any of your items scanned. So if we can't scan them, we can't let you in, right? Because you're not allowed into the court unless all your things have been scanned, right? And because the scanner thing is not working, you're not today, thank you, right? You can't come in, right? Or it's like having 3 sets of stairs, right? And your case is on the top floor, right? And you have to use staircase number 3, but it's got red tape across it and, traffic cones, and it says, crime scene, do not enter, right? We say, oh, well, I'm in court today, in court number 10, and it's on the top floor, and I need to go up those stairs. I'm sorry, not today, sir, they're closed, right? Well, is court 10 open? Yes, sir, but you can't use the stairs. You'll have to use paper stairs. Well, can I use the lift? Yes, but it's not stopping on that floor. It's been programmed not to stop on that floor. Well, how can I get to that floor? Well, if I don't, turn up, I'm going to get an order made against me. Oh, I'm sorry, sir. It's just the stairs aren't operating. We're not operating the stairs. You can't get to where you're going. This is effectively the type of thing that this petitions policy has been inserted in to say, no, you can't do this, you can't do that. We've been told not to let you do this. We've been told not to let you do that. It's all these staff members, the staff members are under the policy, right? But they're not elected MPs and they're not judicial. And they've been told basically to turn people away, right? When we've got a right. And it's not even, the policy is not lawful. There's no powers. There are no powers here to make that policy for that committee or for the whole chamber or for judicial function of the House. These these policies can be made for departmental government things and things that are listed here. And there's like about one committee that can make its own policy for itself, right? But not for public petitions committee. So you just can't have it. You can't have that policy. It's actually obstructing the function of the thing which it's meant to provide, right? It's effectively like saying, right, it's like having a car, but, the car doors don't open, effectively. It's like saying, we've got a policy, here's your new car, sir, but, there's a new usage policy. It's like buying a car, right, from Nissan, and they have a policy where no car owner is allowed to open the doors on their own car, right? That's effectively like what they're saying. Oh, here's your new car, sir. You own it. Here's the keys. But can you sign this policy to say that you won't open any of the doors, sir, right? Well, how do I drive it? Well, that's not our problem, sir, but that's the policy, So that's what they're doing, because they don't really want you to make full use of it, because it's not desirable. It's not desirable now to big political parties and big corporate business and control of local councils and things like this. They don't want us to, if you couldn't get a redress from your local council, they don't want you to go to a higher authority or to a different authority, because they want the council to effectively keep control, because the council don't have control. The control goes somewhere else, right? Even if it's still the government, even if the same political party is in government to a local council area, you're taking control ultimately away from that council and saying that there is a higher authority, and possibly even all of England, like Michael Westwood, 3 million signatures, that it could be possible that the whole country of England might disagree with a local council on something if they suddenly become interested in it and have an interest in it. Which, if you're Bill Gates, you could buy an entire town centre and have interest in it if you can afford to. But they're saying that money can buy land and a right to bring a case to a local council, but if you live anywhere around England, but if you've got democratic power and an interest in the local area, we don't accept the currency of English votes, right? It's like saying, we accept Scottish pound notes. Like this, I've said this before, right? If you've got Donald Trump in Scotland, right, and he's got Scottish pound notes, right, some places don't accept Scottish pound notes. But if he can buy, right, all Worcester, right, if he can afford it, and say, right, I'm building a shopping centre there, right, that's money, right? And he's got the right to bring his case to the local council, because he's got a lot of Scottish pound notes. Money bought him a case with the council. But what they're saying is that if people in Scotland are interested in Worcester, right, if everyone in Scotland is interested in Worcester, right, but they don't have any Scottish pound notes, but they've got votes, right, and they don't want, right, someone to build a shopping centre in Worcester, then they don't have a right to bring a case. Well, they do, because they can submit an objection. They can object. But they say, no, but not on a petition. Well, actually it is, because a petition a petition to a local council is democratic governance of a local council. An objection to a planning case at local council is objection. It's the same currency, right? It's the same currency. The same currency of 10,000 people in Scotland objecting to someone in Scotland buying land in Worcester and building there. The currency of 10,000 people in Worcester with no money going on the website and objecting is the same currency as those 10,000 people signing a petition to Worcester that they don't want someone to build something because they got an interest in it, or to Parliament. And Parliament are trying to say that, you can't bring it to Parliament, or that you can't bring your democratic votes to Worcester from Scotland, but we accept money. We accept pound notes. If you want to buy all the fields there, you can do what you want to it. And in fact, if you can persuade the council, then, the people there, the voters who actually live there, don't even have a say in what happens to it because, just obliterate it all. And apparently they do not have a right to go on e-petitions and complain to the government and get the whole country to back them up, right? And share it online to stop that happening, right? Which is an obstruction of this policy, which cannot exist because it is obstructing a judicial function of citizens of England to get redress in a high court and not have to pay some lawyers ridiculous amounts of money in the Royal Courts of Justice or whatever, because it is free, because we are paying for it and funding it. And all this Gordon Brown, the Supreme Court or whatever, it's tosh, because, he's trying to make it, it's VIP now. It's like the election petitions. You can only bring an election petition now if you have got the £5,000 deposit up front. It's £5,000. Yeah, it's meant to be under the privileges of Parliament and the right of the subjects to get redress, which is free. But now they've put a price cap on it. Only if you're very rich and have got money, you can challenge an MP's election, right? Even though it says that, the High Court, the High Court could be the High Court of Parliament, in my opinion, right? But people haven't got that money, and they don't necessarily know the law, right? So MPs are getting away with, no one's challenging them. Oh, we'll let the Electoral Commission sort it out. Yeah, an Electoral Commission which is similarly run to this new petitions team under these insane, fabricated policies which really are grooming staff to some kind of agenda which obstructs democracy. But yet they're saying, we're providing a brand new service. It's great, right? It would be great if there was an obstructive policy. And the same with the Electoral Commission. They're actually not. They're not holding MPs to account for crimes and offences. Neither is the Advertising Standards Authority. It's not in our remit, right? And we can't afford to. They're actually making it so we cannot get redress. We cannot hold them to account. I cannot get Nigel Farage in a election court because I don't have £5,000, right? It's money. And the way to do it for free is being obstructed by excuses and lies. Because if e-petitions are not through your local MP, it's a Parliament process. It has to be through some MP, which is why they've got a committee. They have got MPs, they have got a committee, and they've got a chairman, right? And it's a petition to that committee. Now, if you ain't got a right of surgery with that committee, it cannot be lawful. How can it be lawful? Because they're saying that you don't have a right to surgery with the particular member who is in charge of that parliamentary committee. You don't have a right to surgery with them. So you cannot, it's like, it's like saying you're not allowed to consult Erskine May book. We don't want to consult over it. But yet they're saying that, you can go to the Journal office and get a clerk to advise you there if it's on paper. Well, if there's a right to have a clerk to consult two-way conversation on submissibility on paper, then how can there not be a legal right to do that electronically when it's stated in the creation of the process that it's electronic because now it exists and it's possible? And it's the same as paper. So it cannot be lawful. It cannot be. It cannot be a lawful judicial process. It is an abuse of a process and a perverting the course of the justice. Because it's like saying the MP will not see you. The MP will, if he's too busy, right? But no, he will see me because I've got a legal right to see him, right? This is the thing. So, that policy, there's no power to make it. there isn't any power in these standing orders to make that policy. So how they've done it, I don't know. When the petition is, every individual petition is a separate claim. It's the same attitude and the same strategy as we're finding from these recent governments, increasingly more and more concerning, in more recent times, probably getting worse from around Tony Blair, from when they started putting those attorney generals in from the House of Lords as well. I'm not saying Margaret Thatcher wasn't bad, but it's got increasingly worse and worse and worse, because all you have to do is look at their own privileges report. Their own privileges report, which is presented to the public, for their own members. Where are the 5 Privileges Acts? Do we know how to remind us of them, or just compare them, let's discuss what they meant and the basis of them, whether it, was pre-existing or still existing now, given that some of them were made after 1688, after the Article 9 that they obsess on, right? No, they don't want to mention them. They haven't mentioned them. You can't get through a privileges report without mentioning 5 acts that are entitled Privileges of Parliament, right? Well, they mentioned the Australian one, going down under. Is that implying something? So, and then, when they do the one, and they're actually basing the entire report around one law. They don't even quote it. They don't even quote that law. They're actually all worshipping this Erskine May kind of, or this kind of like interpretation of it. They got this interpretation of the law, right? And they're all worshipping this interpretation, which isn't even the actual law, right? And like framing it as the law, and then getting everyone to, and then they're going around preaching it and teaching it to everyone, and excluding 5 entire acts, which are also the actual law primarily, and in fact came before, during, and after that, right? It's delusional. And what they're doing is they are selling a misinformation and an under-informed information in order to mislead and deceive. And in the very report, it says that, MPs are liable and responsible for when they mislead and deceive. But that's the report. It's misleading and deceiving. So it's, it's mind-blowingly astonishing and astounding, but they're managing to con each other, and there are naive MPs who, I'm not saying, and don't get me wrong, right, like Carla Denyer is a new MP, like the Green Party, supposed to be kind of like, fresh and sort of new, but people like that are getting misled and gullible by these reports and committees. It's like sharks in the Parliament, misleading other MPs, which is kind of like Jimmy Savile, but instead of touching them up with their hand on their knee or leg, they're actually touching them up with false information. They are abusing them by misdirecting them and misleading them, which is, something that John Burkow was talking about, being misled or whatever. And then the public are being misled because they don't really want us to exercise our rights or use the functions. And the MPs don't really want other MPs to be able to fully, properly have access to their rights either. So they're just like, they're lying to, it's delusional. It's delusional and fantasy, and they're trying to, it's conning people. They're con artists, charlatans. That's the word that they traditionally use for it. It's the charlatans, right? And we're being subjected to all these you know, ID cards, surveillance, all these different things, threatening the Prime Minister's now to take driving license off people if they don't pay bills, all these things they're threatening us with, and, you know, all this immigration coming in, things that people aren't happy with, and when they're trying to get a resolution for it, they're obstructing the resolution, basically, and obstructing our powers as voters. The people who voted them in and put them there, they're actually not being accountable to them. And they're saying that, you know, we don't have the right to remove them if we're not happy with them, or we don't have the right to, you know, point out malpractices, or they don't want us to make the malpractices public. Well, how are we supposed to get people to sign and support the complaint and grievance? Or we don't want loads of people to support it, because then we might have to do something about it. Otherwise, then reject it or say it's nothing to do with us, or make you word it in a way where it's not very potent, or that you're unlikely to, you know, get the resolution. This is the thing. Or we don't want it to be on the public record, you know, or whatever, or don't want it to be officially accepted. This is not acceptable conduct of these people in government. So, you know, there's no power. There's no power in these standing orders to make a policy for the judicial function and process of the House of Commons, whether it's in digital or paper form, because otherwise you're being obstructed from a surgery with the MP who's appointed to receive electronic petitions, right? By putting an obstruction in between you, which they can't do that. And, you know, it's, if you go by the 1832 committee report, you know, it's pretty much, you know, and it's a lot more relaxed. But the thing is, they said they wanted to relax the rules. They were talking in 1991 and 1993 and 2004, like, oh, we're going to relax the rules. But relax them from what? Erskine May had tightened up the rules. When Erskine May published his book, and then progressively, they're writing all these etiquette and rules when, you know, in 1832, before Parliament burned down, they weren't. They were quite relaxed and open. I know these all kinds of language, you know, and I managed to, you know, get these petitions presented. So I don't know why in 2004 they were trying to make out that, oh yeah, we're going to modernise it and relax it, but they didn't. They actually got it's got even more restrictive and stricter. In fact, it couldn't be less. It's less transparent. It is more strict, and it is highly authoritative or authoritarian and misleading. It hasn't been relaxed at all, you know, and it was relaxed. You know, there's no need to relax it because it was apparently relaxed in the first place to a certain extent in 1832. So, you know,